It's Tuesday, it's August 12th, 2025. We have some court today. We have all of the things going on. But if you were with us last week we covered a court hearing in Massachusetts. Same old courtroom, different judge, different case, mostly different lawyers, except for Attorney Lally, who had been on the stand a few weeks before that in the Miles King case. So there's a discovery hearing set for today. My anticipation is that there will be some discussion about discovery in the King case, though I am not covering that case per se. We have so much to talk about with Attorney Adam Lally, who had been the prosecutor on the Karen Reed case before they brought in Hank Brennan, with Trooper Proctor, with what seemed to be systemic and ongoing discovery issues in Massachusetts, especially and particularly with the Norfolk County District Attorney's Office. So though we are not covering per se the King case, it is a accusation of a homicide, so it's a murder case. Miles King has been let out of jail on a significantly low bail and house arrest because of the discovery issues. So someone who was no bail has already been released because of the discovery issues delaying trial. This has been delayed now for years. It seems that there are still things from the very beginning of the case that the defense does not even have. So we are seeing these discovery issues pop up again and again and again. And it's wild, the stuff that was being complained of by the defense in the Karen Reed cases going on in these cases too. And these discovery issues are just a disaster and shouldn't be happening. So I am keeping an eye on the discovery because I'm A, curious what the courts are going to do, and B, somewhat stunned that this is as bad as it is. Turn over the discovery. It's really not that confusing. We just got to the Zoom part of the hearing regarding the King case that we had been waiting for since this morning. And the Zoom hearing is cut and the pool camera cut before any of these hearings ever got started. What happened in the Miles King hearing today? We don't know. We won't know what's going on with discovery in the King case until we check the docket and it's updated. So I will check the docket. We will see what's going on the hearing on Thursday and we will figure it out. I want to know what happened in the King hearing, but what we heard the DA say is that the court has a filing that shows what was turned over and when, but does not have a filing that shows which documents are exculpatory, which means the court at some point is going to say, go do this. Ted Daniel posted 40 minutes ago saying attorneys for 5 defendants connected to murder cases, so separate murders in Norfolk County, were back in court seeking the federal download of Proctor's phone and potentially other phone data from Proctor that's not included in the federal materials. Proctor's lawyer said nothing exculpatory exists outside the federal materials because Proctor got a new phone in February 2024. Part of the problem here is that there's a clock on this discovery because there was consideration about whether or not that information would still be preserved by the feds. And so whether they will get it before it is just gone, I can't imagine why the feds would do that. There's a lot more motions I just need to pull regarding that tolling, but also the reason that Norfolk DAs or state police can't just go extract Proctor's phone is because my understanding is that the extraction that exists that the feds have is the only one that exists and everything else is gone at this point, either by it rewriting from iCloud, getting a new phone, the rest of it. So they can't go get Proctor's phone now. They have to get it from the feds. The fight over federal discovery is not done. And the prosecution is in an unusual and difficult position with regard to the federal discovery. We're not going to talk about the late discovery at the moment. With the federal discovery regarding Proctor and whatever else, the issue with the federal discovery is that the prosecutor on the Walshe case, one of them, is Attorney McLaughlin. Attorney McLaughlin was also on the Reed case. Attorney McLaughlin is aware of what is in the federal discovery that was turned over to them in the Reed case via a TUI request. The TUI requests in the other prosecutions were rejected by the feds. They sent the request for discovery and the feds said no. In the Reed case, it was turned over. However, there's a federal protective order with the information in the Reed case. It cannot be used in other cases. Here's the problem. Attorney McLaughlin knows that it exists. And the Rule 14 obligation for Attorney McLaughlin is that if you know of anything that exists, you have to disclose it to the defense. But they don't have it such that they can turn it over because of the federal protective order. But the judge said, but you have it, even though you don't have it. Someone in the DA's office has this information, but the federal protective order says you can't use it in another case, but you have it. And because Attorney McLaughlin is aware of it, she has to disclose to defendant Walshe's attorney, I am aware that this information about the lead investigator exists. It's potentially exculpatory. It's at least impeachment as to Proctor, the lead investigator. So I have to tell you it exists, but I can't give it to you because of the federal protective order. But I have to disclose it to you. And the court's saying, but if it's disclosed and then you can't turn it over, aren't you obligated to review it to confirm that there is no exculpatory material in there? And the Commonwealth said that their position is they can't review it to determine if there's potentially exculpatory information because of the federal protective order. So do you see the circle that we are in now? So the defense attorneys have an argument that this is potentially exculpatory information that can't be turned over, and that becomes irremediable. But then they have to argue that it's potentially exculpatory based on what is publicly known, which goes to the Reed case, not their defendants. They don't know if Proctor said anything about Walshe or any of the other defendants. They don't know, but they have to argue that it's potentially exculpatory. But under the case law in Massachusetts, they have to prove that it's exculpatory. And you're all going to ask me, Emily, how do you prove something's exculpatory if you don't know exactly what it is? Exactly. And if you're the court, you can't order the federal government to turn it over. But I mean, I guess you can issue a subpoena and hope for the best, but it's not going to go very far. And you're stuck in a freaking boot loop with a blue screen of death going, the files are in the computer. I mean, they existed, but we can't tell you what they are. The remedy I would like to see, this is just personally, is that the feds turn it over to a discovery referee, mediator, retired judge, whatever. That person reviews it and turns it over. I don't think the DA's office should be the one deciding what gets turned over in this case from the feds. And I don't think the feds should be deciding either. But we are in a very strange procedural quagmire where the feds are like, we're not giving it to you. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.